My name is Norma Trusch. I am a board-certified family attorney. I practice in Houston, Texas. I've been practicing, about 32 years now. And from the very beginning of my practice, I specialized in family law. Um, and a lot of the years of my practice, I was asked by the court to represent children in divorce cases where their parents were fighting about custody or visitation or some issue like that. And along the way, I heard from my young clients over and over and over again to please make the parents stop fighting. And because the system we were in was the traditional litigation system, I was somewhat impotent. I mean, I could urge the parents to keep the children off the battlefield, but they had lawyers who they listened to, and the process, the litigation process polarized them. And so even if their intent was to protect their children, I think the process itself mitigated against that to a great extent. I did it for many years, and I had started late in the practice of law. I was 40 when I started practicing. So after, 25 years, there was Social Security available, and I was getting pretty burnt out as I approached that age. And then I attended a collaborative law training. And any plans that I might have had about retiring went out the window because I suddenly realized that I could practice family law the way I always had wanted to, which is to enable clients to get through a process that can be painful, gut-wrenching at times, but enable them to come out the other end without having destroyed their children or their family or their estate, and have the potential of being able to be civil to each other and to co-parent. So it was sort of like the answer to a prayer when collaborative law came along. After I was trained, I was very anxious to do collaborative law. And when it first came to Texas, it was attorney only. One of my early cases was with a colleague of mine who I had great respect for, and he and I were very excited about doing this, but we really, to a certain extent, were kind of learning as we practiced. So we had an interesting case with a couple who had been married for 13 years, and when they married, the man had a daughter from a prior relationship, a prior marriage, who was living with him because his ex-wife had a drug problem and rarely showed up at all to visit with the child. And my client was the wife, and she moved, they moved into her house that she had gotten in her divorce. So when they moved in together, the child was 3 years old. They lived together for 13 more years, and then there were problems in the relationship and they decided to divorce. Well, under Texas law, they moved into her house. It's a separate property house under Texas law, and technically he had absolutely no right to have any interest in the house, to remain in the house. And on the other hand, there was a mother out there, a biological mother, for the child, and she, had the rights that the court had given her. So my client really, technically under Texas law, had absolutely no legal relationship with the daughter. But part of the process of collaborative law is for the parties to identify what their goals and interests are at the very onset of the case. When we examined their goals and interests, we discovered that both of them shared two important goals. They wanted to disrupt the young woman's life as little as possible, and they wanted her to have a continuing relationship with really the only mother she ever knew. So when we went to brainstorming about what to do and coming up with options of what would make sense in their lives, not what the Texas law book said was the solution to their dilemma. They decided that the father and the daughter should remain in her separate property house until that girl graduated high school. They lived a few blocks from the high school. Remaining there would disrupt her life as little as possible, which was a mutual goal for them. They also agreed that this stepmother would visit with the child just the same way as if she had what we call a standard visitation order under Texas law. And I guess if the biological mother showed up occasionally, she'd give up the few hours that that woman wanted to spend with her own child. But she ended up with a right to have regular visitation with the child. And when the case was over and after they were divorced, my client and her stepdaughter went on a European trip together. Well, that's something that no court in Texas could ever have done. It's something that if we had approached it from a legalistic point of view, as this is what the law says, this is what you're entitled to, and nothing more, that would never have happened. But because collaborative law addresses the values and the goals and the concerns of the clients rather than the attorney's conception of what they need, the solution was something that was tailor-made to these people in a way that enabled them to have a relationship that was protective of the child and offered the child what she had gotten in the years of the marriage, which is a mother who really cared for her. When Stuart Webb first thought up the idea of collaborative law, it's a very simple concept. Attorneys and their clients agree in writing that they will work towards settlement, that they will not go to court to have their dispute settled, but they will work harmoniously together. And that was Stuart Webb in Minnesota. Meanwhile, in California, there was a wonderful woman named Peggy Thompson, who's a mental health professional. And she was seeing clients going through divorce and being chewed up and spat out by that litigation system in a way that really distressed her. And she and a group of other therapists and sympathetic lawyers came up with the idea of something that's called collaborative divorce, which I'll explain more in detail later. But so we had people on the West Coast doing something and people in the North doing something similar, but the California people really hadn't gotten that one key to doing it, which is if the case doesn't settle, these attorneys can never go to court and will discontinue representing the clients. That's the key that makes the entire collaborative law system works. So one of the practitioners from California, a woman named Pauline Tesler, went, I think, to an ABA convention and heard Stu Webb talk about this new thing that he was working with a few other lawyers who he persuaded to work with him. And Pauline, who is a brilliant woman, immediately understood all of the ramifications and also put together the idea of what they were doing on the West Coast with what he was doing. And she wrote the first really excellent book on collaborative law, which was published by the ABA, which explained how to do it. And it's mostly a how to do it for lawyers. Well, along the way, different approaches to collaborative law have developed. Basically, right now, there are 4 or 5 models that are practiced in different locations, not always the same lawyers using the same model each time, but these models are available in the appropriate cases.